am absolutely delighted to invite you to the first lecture of this year. I was going to say the numbers and then I thought, oh, I might have those wrong actually. So the first lecture of the year, and I'm even more delighted that we have the wonderful Professor Antonia Layard to deliver that lecture. It's a real privilege. And we are fortunate to have Professor Sarah Blandy to chair this lecture. She is Professor Emerita at Sheffield University Law School, Fellow of the Academy of Social Sciences, lots and lots of other credentials, which I won't go into today, so we can get to the lecture. But I'll simply say that her wonderful work focuses on collective and individual property rights, including recently on collective housing and the spatial boundaries of law in relation to fortified homes and gated communities. And with that, I will hand over to our chair, Professor Sarah Blandy. Thank you.
Welcome, everyone. Lovely to see you. And it gives me great pleasure to introduce Antonia Layard, Professor of Law at Oxford, who's giving today's lecture. So I won't go through all of Antonia's credentials either, but I will just say I have known Antonia for many years now, during all of which time she has been a stalwart member of the socio-legal community. She's an excellent doctrinal scholar in the fields of property, planning law, and for example, she co-edits Thompson's Modern Land Law, and she always strives to make her work relevant and to draw attention to social injustices. So Antonia works cross-disciplinary boundaries. She's got some very highly regarded sole-authored publications, but she's also published with a range of other scholars. Her research is always challenging, scholarly, and topical. I think Antonia is probably best known for her groundbreaking legal geography research, inspiring us to think about how law can be read spatially. Her work explores the construction of space, place, and the local through law, legality, and maps. Public space, highways, and urban law are of particular interest, enabling Antonia to provide fresh analyses which highlight the processes and implications of spatial governance. Current focus of Antonia's research is public land law, and I now hand over to her for what I'm sure will be a fascinating, thought-provoking lecture. Over to you.
Should we go to Dartmoor? So let's go to Dartmoor. Dartmoor is 65% granite. It runs to 368 square miles, about half of which is unenclosed common land, and about 3/4 of this is moorland. There are also 450 miles of public rights of way. It was designated in 1951 as one of the first national parks, and it's mostly just owned privately. The Duchy of Cornwall, for example, owns around a third, and there are several other large landowners. So Dartmoor has over 160 tors, which are outcrops of granite, usually on a hill from which you can get great views. And there are about 1,500 semi-wild ponies on Dartmoor, owned by Dartmoor commoners. And because such a large amount of Dartmoor is commons, we have the 1985 Dartmoor Commons Act. And that established a Commons Council, gave obligations to the National Park Authority. And on Tuesday, if you've been following the news, you'll have seen that Mr. and Mrs. Darwell went to the Supreme Court to seek a declaration that Section 10 of the Dartmoor Commons Act prohibits wild camping, or saying that it doesn't permit wild camping. So the section says a right of access to the commons on foot and on horseback for the purpose of open air recreation. And we'll come back to that section right at the end. So Dartmoor Commons are the only place in the country where wild camping is permitted. At first instance, Justice Flo found for the Darwell. So he held that Section 10(1) does not confer on the public any right to pitch tents or otherwise make camp. So if you want to camp on Dartmoor Commons, you've got to get the consent of the landowner, said Justice Flo. He also said that Darwell was a quintessentially private law dispute. And I want to suggest to you it's a quintessentially public law dispute. And that's what I'm going to try and explain today. The reason this matters was because the Darwells bought their property in 2013, nearly 40 years after the 1985 Dartmoor Commons Act. So they were clearly out of time for any judicial review action. but framing it as a private law dispute, there were no time constraints. So the Dartmoors won at first instance, but they lost in the Court of Appeal. And in the Court of Appeal, the Master of the Rolls, Geoffrey Voss, held that the appeal raised a short point of statutory construction. What do these words in section 10.1 mean? Are they clear and unambiguous? And he held they were, and that they allow the public to engage in open air recreation on the Dartmoor Commons, provided they proceed on foot or on horseback. And he said open air recreation includes wild camping. So he said as follows: if you're out walking on Dartmoor and you rest, is that recreation? Yes. If there's a tarpaulin between you and the weather, is that recreation? Yes. And if you zip the tent up so that it's closed, is that recreation? The Master of the Rolls held yes. So he had no difficulty with the statutory construction and said that you are permitted to wild camp on Dartmoor, although you must undertake the activity in accordance with the bylaws that the National Park Authority had promulgated in 1989. The other two judges agreed. So that is public land law. And this is my definition. Public land law is the regulation of land by the state in the public interest. That's it. You can go home. No. But as the lawyers here will know, land law is conventionally framed as a private law subject. So it's said to be a private law subject that creates a discretionary framework between parties, buyer and seller, borrower and lender, landlord and tenant. Land law teaching tends to focus on ownership and often on transactions. And one of my favourite quotes, P.H. Kenny wrote that the suggestion that land law is just conveyancing is the taunt of the Philistine. Yes, we like to think we're not just doing conveyancing and land law, but most land law teaching that we do would be framed as private law teaching. So I want to suggest to you that the public interest is implemented into property, primarily by legislation and administrative decisions, though also by practice and social norms. Sarah is much more of an expert on that, and I'm not going to cover that aspect today. I'm also not going to challenge the public-private distinction. I'm going to proceed on the basis that we have private law and public law, however much we may challenge that in other fora. What I'm going to look at is what Kevin Gray has called the public character of property. So why does it matter? Why should we study public land law? Because as lawyers, we're only seeing part of land law, the transactions between private parties, but not what a landowner can do with their land. So a landowner can clearly, a landowner may be liable, in tort. We have the property torts, we have nuisance, we have Ryan's and Fletcher, we have trespass. So there are some constraints on land use, but these aren't really even taught in land, these are taught in torts. We have to give the good stuff to the tort lawyers. Not only can we not do that. And this creates what Christopher Essett has called the normative boundaries of ownership, principally give and take, e.g. in Fern. So Tate and Fern was the case where it was held that there would be a nuisance caused by overlooking from the Tate balcony. You're familiar with that case. Also the relationship with statutes, so Marchick, which was a water pollution case, Biffa, which was another pollution case, and most recently in a case called Manchester Ship Canal 2, again, another pollution case. So we have private law, we have the property torts interacting with authorisation. But what I want to suggest to you is while the property torts matter, and they should come back to land law, guys, we are far more constituted by the public interest, by legislation and administrative decisions. And to understand property, we need to understand public land law. And I may be biased, but it's by far the most interesting bit. So, is it public property? So we're just going to do a slight detour into public authority land law, and then we're going to go to public rights. And public authority land law is important. I'm not sure the time is quite right for it to come into land law. It may be better off left in administrative law, but I will explain why. And that may be a temporary situation. So in landlord terms, whoever owns a property, a private individual, a public body, owns it in the same way. Freehold estates, leasehold estates, covenants, exactly the same. And if you're the Crown or if you're a government department, you own it as a corporation sole, and again, there's no distinction. So 10 Downing Street, it's just owned. It's much more complicated for local authorities. In local government law, there is a framework which even the Supreme Court in last year's case of Day and Shropshire Council called puzzling. And essentially what the Local Government Act does is it creates obligations for local authorities when they own land, so that, for example, they cannot sell at an undervalue. Many exceptions have crept in, particularly in 1980 when Thatcher came in. Some really important exceptions were written into the Local Government Act in 1972. And just to give you an example of public authority land law, I'm going to use the case of Whitstable, as it illustrates the distinction between public and private law and how the difference this makes. So, Whitstable Council sold a site, which is on the far left, and this is known as the Oval Chalet site. And they sold it for £165,000. It looks out into the sea, at what was agreed to be an undervalue. So they sold the land at an undervalue. And while the facts are complex, that much is agreed. The next picture is a planner's picture. And what was proposed, this doesn't come from the case, this comes from additional research online. So I'm taking it on trust from what I've read online. It's not in the case itself, but what the developer had proposed to develop the site for housing, including open space. But the planners will know this was written as a planning condition as landscaping. So clearly landscaping and open space are quite different. So what happened was we got these private houses here with a bit of landscaping, but the public space was lost. So there were two issues here. One, were there any public rights in the land under a statutory trust, open space, Day and Shropshire? So this was long before Day and Shropshire, and Justice Dove said there were no rights in the land because the land had not been laid out or landscaped. Now, I don't think this interpretation would survive last year's Supreme Court case in Day. But more importantly for our purposes, what Justice Dove said is while there was a sale at an undervalue, he exercised his discretion not to grant a remedy. So because the case was brought in administrative law, the judge has discretion. And he said there was delay. And the delay had been for 6 to 8 months, in part because Whitstable Council had had a really difficult time getting information. Sorry, the Whitstable Society had had a really difficult time getting information out of the council. So an extension was given at the leave stage, but Justice Dove held that this delay was extensive and undue, and he held that in the interests of good administration and to avoid prejudice to third parties, he would exercise his discretion to refuse relief. And he justified his conclusion by using this quote at the top, which comes from Lord Justice Hobhouse in a public contract law case, if you study that in administrative law. And what it essentially says is we give to private law what is due to private law, and we give to public law what is due to public law. And Justice Flo and Darwell in the first instance also relied on this. This was one reason he said it was a quintessentially private law case, Darwell camping on the Commons. So public authority land law exists, particularly for local authorities who are subject to legal and policy restrictions. But because local authority land isn't generally held on trust, unless it's open space, the land law nature is completely the same as for other owners. So what really matters is the discursive terrain, to use John Page's term. So how you talk about public property. So the discourse around public property is probably more effective than any legal constraints. Public authorities who own land have no human rights, probably. That's Aston Cantlow. There's a very good critique by Howard Davis. And the Joint Committee on Human Rights also weren't quite sure. And they have to observe human rights. So Article 8, right to home, possession, and they have to allow protests in accordance with other rules, Articles 10 and 11 of the Convention. So public authorities do have a slightly different regime in relation to human rights. Are universities public authorities? We used to think not in protest cases. Over the summer, there were 2 interesting decisions by Justice Johnson. There were summary applications at Birmingham and at Nottingham, where he left the question open. Watch this space. So that's public authority land law, which I think is really important and matters a lot for campaigns and planning on the ground. I think it's better understood at the moment as administrative law rather than land law itself, but I think it's worth considering. What I think is important, and I think we should all study in land law, are public rights. And we don't study public rights, even though they're in land, and they're straightforward and they're significant. So what are public rights? You might have a public right in a village green, and the village green cases draw a distinction between as of right and by right. And if you want to read more on village greens, read everything that Jane Holder has written. You might have a public right under a statutory trust, which is what the Supreme Court held last year in Shropshire, where Peter Day fought so valiantly to bring that claim to its end. You have something akin to that in the Commons. You have commons rights, and there I would read everything that Chris Rogers has ever written. But most importantly, I think we have highway rights. So a right is in the highway. These are public rights. Every time you leave your home and step out on the pavement, you are using your public property rights. And they're significant. There's about 180,000 miles of public rights of way. And yes, we have lost footpaths. We've got to claim. The current deadline is 2031. In Wales, that's about to be abolished. But public rights are binding in unregistered land, including adverse possessors. You can see that in Pine Graham, land lawyers. And they're overriding in registered land under Schedule 3, Para 5. Now, if you teach land law, we always go Schedule 3, 1, 2, 3, and we stop there. But if you look at Para 5, it's very straightforward. Public rights are overriding, they bind. So if you buy a piece of land and it's got public rights in it, then you are bound by it. So it's very easy to incorporate this into our land law studies, and I hope that we will. But it also goes to show that land is not necessarily about private property. Land is also about public rights and private rights and how these coexist. And what we saw in the Supreme Court was that they're pretty relaxed about the coexistence of public rights and private rights, and that there's no hierarchy. Just as a slight aside, we talk about private property a lot, but I'd suggest to you that it's a little discursive. If we think of a public authority, do they have rights in nuisance? Yes, if they were being flooded or if they were exposed to smells. Would we say that the public authority's private property rights are being infringed? Now we might, or we could just call them property rights. But if we do that, we start to really break down the naming of private property rights versus public property rights. So what I'd like to suggest is that we look at the concept of authorized property. And this means that ownership and use are permitted only as authorized. So we can't do whatever we like on land. We can only do what, in particular, Parliament lets us. And I'll look at three pieces of legislation very quickly. The first is the 1947 Town and Country Planning Act, which is mandatory in discussions of these sorts, and really lovely to have planners here. Thank you. But the Planning Act was revolutionary. So we've had building control going back to the 17th century. We had interim development, we had ribbon development, and then we had the Uthwart Committee. And the Uthwart Committee was no set of radicals. There were two barristers, KCs, and an existing and future chairman of the Institute of Chartered Surveyors. So this very respectable committee put together a proposal that had enormous political support. You see Churchill there, though obviously this was a Labour intervention, to introduce a requirement for planning permission. At the time, there was also the betterment levy, which Michael Edwards knows far more about than me, so I'm going to suggest you read everything that Michael's written about betterment. Betterment no longer exists, but it was a form of development. Critically, you were no longer allowed to develop your land without obtaining planning permission. No compensation was paid. Now that's obvious, we know that. If we want to develop a piece of land, we have to apply for planning permission. But sometimes I think when you see dicta and you say property rights cannot be taken away without compensation, what is clear and what the cases confirm is that Parliament can intervene if it expressly authorises the limitation. So planning continues today, and 14% of all applications don't get permission. So we're not going to compensate those 14% or the people who don't apply. And Desmond Heap, writing in 1987, a very eminent planning lawyer, no compensation was payable because no loss could have been sustained by the landowner who no longer had vested in him the development rights in his land. So it was practical. You can't have a planning scheme if you've got to pay out compensation. But it's also conceptual. Development rights were nationalised in 1947. Once the Act came into effect in 1948, land in Britain was never the same again. You have property, but as authorised. And Lewis Silkin, introducing it in 1947, talked of a bill of this magnitude and historic character. It was widely understood that this was a really distinctive intervention. The next one. The next one is the Leasehold Enfranchisement Act of 1967, another Labour intervention. And we're going to look at this through the case of James in the UK, which is a decision in the Strasbourg court in 1986. And the question here was whether leasehold enfranchisement breached a right to property. So a right to property, I put it up there, every natural legal person. So a natural person is a human being, a legal person is a company. But here it was the trustees of the will. And in a leasehold enfranchisement case, you have a freehold, and then you have a lease. And a freehold goes on forever, a lease goes on for a period of time. Landlords. So what happens at the end of the lease is that you have the reversionary estate, and it reverts back to the freeholder. And there may be obligations to pay a ground rent, there may be other controls that are part of the lease, but it's the reversionary estate. And the question is whether a leaseholder can enfranchise themselves. Can they purchase the freehold below market value? So in 67, you could even extend it for 50 years and then apply for enfranchisement. That loophole got shut. But you can see that the trustees of the will were concerned. And the general approach under A1P1, which is the right to property, is that if somebody is deprived of their property, compensation is payable. If there's a control on use, whether or not it's payable is part of the fair balance and the proportionality assessment. So a distinction is made if you're deprived of your property or if there's a control on use of your property. And here there was a deprivation. The freehold estate was deprived. Compensation was payable, but it was not market value. And the Strasbourg court holds that there's no breach of A1P1, there's no breach of the right to property. This was within the UK's marginal appreciation. It had been Labour policy for many years, and the 67 Act was enacted to achieve greater social justice. It didn't matter that compensation was not at market value, even in this case, deprivation. So leasehold enfranchisement is continuing. And I wondered if anyone knows which radical said this. So this was in December 2023, and the radical there is Michael Gove. We have quite significant cross-party agreement that we should have reform to leases. So we've got the 2024 Act, which is inactive and not enforcing the key parts yet. And the Labour government have said that they're going to bring in a new piece of legislation to bring the end to a feudal nature of leases. And we've seen the use of the word feudal in relation to leases for some time now. So critically, enfranchisement for the leaseholder is also disenfranchisement for the freeholder. Yes, it's a serious limitation on the right of alienation. But it's clear the Strasbourg court confirmed that it can even be undervalued without a breach of A1P1. So that's my second example of property that's authorised. And then we have the right to roam. So the right to roam came in 2000, again, under a Labour government, Michael Meacher, standing up in Parliament. And what it does is it designates large areas of the land as access land. And if land is designated as access land, then we have what is colloquially, but not the legislation, called the right to roam. So you can go there, you can take a dog on a lead, there are obviously some restrictions about dogs. You can take a mobility vehicle, or a number of things you can do. What you can't do is limited in Schedule 2. So my favourite is that you can't take any animal other than a dog on a lead, which begs the question. But critically, for Dartmoor, you can't camp. So the prohibition on camping comes in Schedule 2. And that prohibition actually is exactly the same as the 1925 prohibition on camping on urban commons, metropolitan commons. So legislation includes a prohibition on camping in the schedules in 1925, long before the 85 Act, and 15 years after the 85 Act in 2000. So the fact that Section 10 may not say you can wild camp, Schedule 2 doesn't say you can't wild camp. It incorporates the 1949 Act. Occupier's liability is modified, as it is under the Dartmoor Commons Act. And when the legislation was going through Parliament, particularly in the House of Lords, Lords complained that it was a diminution in the value of the estate. And Lord Leicester took a fairly robust approach, saying it was a fair balance and there was no infringement of the right to property. So once again, what we have is property as authorised. So this is about property's public character, and it's not just public law, but also private law. So I don't want to suggest that only public law authorises property. There's also the property torts doing their work. But I suggest to you that the public law limitations for property are underappreciated and understudied. So, for example, you can paint your house any colour you like, unless it's in a conservation area where restrictions apply or you're putting on advertising. You might have to allow scaffolding on your land so your neighbour can build their kitchen extension. If it falls apart, the council can have an empty management dwelling order. If you put a shark in your roof, you will be required to obtain planning permission. Having obtained planning permission, the local council may then decide to list it as a local feature, making a material consideration in future planning determinations. We think it's private property, but there are an enormous number of things you can't do. If you want to rent it out, you can seek possession at the end, but these rules are about to change in the new 2024 bill coming through. You might have to apply electricity and gas. You might have to make it protected against fire. So there are many obligations on land. If you have a listed building, you have to get listed building consent before you can make changes. You might get compensation for alteration, but not for demolition. If you want to demolish your property, obviously you can't do that unless you have planning permission. So the list really goes on for some time about what we can do. And what I want to suggest to you is that even if we think of it as private property, it's authorised as. And so these public interventions are really much more significant than property theorisations often acknowledge. So then let's go to statutory interpretation. Now, you may not think this is as exciting as I do, and Lord Burrows does, but statutory interpretation is the key tool in the toolbox for public land law. It's how we see what did Parliament say? Because if Parliament authorised the intervention expressly and clearly, then the courts abide by it. So Lord Burrows was Andrew Burrows as an academic who went up to the Supreme Court, and his Hamlin lectures were all about the importance of statutory interpretation. Now, one question is, when you interpret legislation related to property, should you take a view if it's disproprietary? So if you think it's disproprietary, should you favour the landowner in your interpretation if there's ambiguity? And this is the key question at the moment. And Lord Justice Buckley in 1976 held that that was a case, in a case called Methuen. And this again was a quote that Flo used in first instance in Darwell. So he built on Lord Justice Buckley. However, Lord Justice Buckley has been repeatedly rejected that analysis. And this is the analysis by Lord Justice Millett, again in a leasehold enfranchisement case. And what he says, you've got to look at the Act as a whole. And while it's expropriatory of the landlord's interest, that reversionary freehold has to be sold at possibly below market value, it is the duty of the court to construe the Act fairly and with a view, if possible, to make it effective to confer on tenants those advantages which Parliament must have intended them to enjoy. And this is a quote that Sir Geoffrey Voss used in the Court of Appeal in Darwell. So the current approach to statutory interpretation is purposive, in context, and objective analysis. And the current point of reference is usually now British citizenship, which is what the Master of the Rolls, Sir Geoffrey Voss, did. So if you do that, you look at the purpose of the Act, so the Dartmoor Commons Act, if it's about regularising access, and you try to see whether or not that Section 10 provision can be interpreted within that context. Now, I'm not going to take you through all these property models. You'll be really easy to know. There are many property models. What I would suggest is that some property models do take on board authorised property, so progressive property, for example, the gender setting, Jim Harris's ownership spectrum. The really great work here for me is Eloisa Scotford and Rachel Walsh's paper and Chris Rogers' work. But often property is theorised from first principles, and there's an assumption that legislation is not as relevant as case law. So I think all property theorisation could take all property theorisation could take the idea of authorised property on board and consider how legislation impacts on it. I think we would end up with more robust models. Right, now it gets really exciting. This summer, in a decision called Manchester Ship Canal 2, Lord Reid and Hodge in a judgment with which all 7 justices agreed, held that there is a fundamental right to peaceful enjoyment of property. So just as we have a right of liberty, a common law, we also have a right of property. And these are exciting times for land lawyers because we haven't seen that kind of language before. We've always worked with property rights, but this idea of a right of property is quite distinctive. And they linked it in paragraph 16 and 17 to access to justice, so that if you have property, you should be able to go to court, because access to justice clearly is a fundamental right, or Justice Walden with them. But they also talk about a right of property. And Lord Hodge, in a decision called Symmetry in Swindon about a planning condition, also talked about a right of property. Why does this matter? It matters because it could change the approach you take to statutory interpretation. And the approach you then could take to statutory interpretation is to apply the principle of legality. So students who studied constitutional law or constitutional lawyers will know this very familiar paragraph by Lord Hoffman, who held that fundamental rights cannot be overridden by general or ambiguous words. And this was absolutely in play on Tuesday in the Supreme Court in Dartmoor. Yes. So the question was, is the wording ambiguous or is it general? And there's some quite complex arguments about bespoke wording. Now, why can fundamental rights not be overridden in this way? Lord Hoffman held because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. So the presumption is that they were not intended to be infringed, but it can be achieved with sufficiently express and clear wording. And so if you read the whole paragraph, it's slightly more nuanced than this very famous part of the paragraph suggests. So the question is, if the right of property is now a fundamental right, and there are general or ambiguous words, we apply the principle of legality. How does that change it? So this brings into play quite fundamental constitutional issues. Lord Hodge, who wasn't on the Darwell panel, but was very much involved in Manchester Ship Canal, wrote this extrajudicially. And on the one hand, it's quite straightforward. The twin pillars of our constitution, the sovereignty of the UK Parliament and the rule of law, and the separation of powers which links the two. So anyone who studied constitutional law will find that quite familiar. The question, of course, is what we mean by rule of law. Do we mean formal or substantive? And what role will the courts take in intervening, particularly when there's ambiguity? So no one, I think, would suggest that the courts shouldn't be involved at all. I'm quite fond of David Howard's phrase in the nuisance law context of private law's emergency parachute. So you might still have private law that can step in. The question is the extent to which the courts should be interpreting ambiguous words, e.g. section 10. And here we are again. So clearly, it is for the Supreme Court to determine what that means. The Court of Appeal did it very straightforwardly. I'm a big fan of the Court of Appeal's decision. Clear, both the structure and the approach. You may have read in the papers that counsel for the Darwell said that this meant a right of access to the Commons on foot and on horseback and nothing else. So if you want to sit down and eat your picnic, you cannot. If you want to take a rest because you've overestimated your fitness, you cannot. Thanks. That unfortunately leads us to an absurd interpretation, which is the one place you don't want to be in statutory interpretation. So that particular interpretation seems unlikely. The question is, what does open air recreation mean? I would suggest to you that it means exactly as Sir Geoffrey Voss explained, that it might include sleeping under a tarpaulin or a tent, because it's not excluded in Schedule 2. But we will see what the Supreme Court say. And for lawyers, what's even more interesting in a way is what they will say about the principle of legality, because submissions were made on that point by both sides. So the KC, Richard Honey for the DNPA, the National Park Authority and the Open Spaces Society, who were interveners, suggested this idea of responsible access, and that predated the Act. But that could still be a trespass if it was not authorised. And so the question is, if the legislation isn't sufficiently clear, does the principle of legality apply? Now, it's clear that access is here. The question is whether it's camping. So if there's ambiguity, and both parties very much say there isn't any ambiguity, and the first instance Flo said there was no ambiguity, there was no wild camping. The Court of Appeal said no ambiguity, there was wild camping. Okay, you can see. But once we get ambiguity, then we get the principle of legality, potentially. And that would be very exciting, because that would be a new intervention. So last slide. This is all at some level quite fundamental. So the quote from Maria. So where we stand on this will depend on our ideology. So this is written in terms of the collective interest in nuisance in tort law. But as I would quite like to include tort and land in a more generous mixture. So where we stand on this will depend in part on ideology, as well as on the ideologies that we perceive to dominate administrative and judicial decision making. Maria cites Patrick McCausland at this point, and actually I went back to reread some of Patrick McCausland's work when I was writing this, and some of the older work, some of the debates in the 1980s. It's incredibly illuminating today. The balance in land and public interest land law, I would say, is between the individual and the collective, or private and public, if you prefer. And some ambivalence, says Maria, about whether the individual should be protected from the collective or vice versa is inevitable. So the extent to which we allow the collective to impact onto private rights. So one of the arguments counsel for the Dartmoors made was that the Supreme Court justices should not distinguish between a property right for a small house and for a mansion. So they're trying to say, well, if it's a property right that's infringed, it doesn't matter the extent of it. If it's even just one night camping in 4,000 acres that you own, that's the same as a small house. So public interest law is deciding where we draw the line between the individual and the collective. I hope that we can all study it and agree that these are interesting times for public land rights.
Thanks so much, Antonia. Fantastic. Okay, questions? Everyone's stunned into appreciative silence.
I'm just going to be able to see any online questions.
Oh, yes.
If you,
yes.
If you'd like to put them in the Q&A.
Okay. Should we just take two now? Let's have two together. People who had their hands up.
I was just thinking, Antonia, thank you. That was so informative and so exciting. Thank you. Just back to recreation point. I'm looking at this in greens and seem to be how recreation is a big category. I'm just wondering how that sort of fits within this. Recreation is now something which has other it's a useful container, if you like, for thinking about land protection.
Should we have your question as well? Yeah.
Sure, thanks so much. I want to add further, so Rich, lots in there. I want to add a further dimension, specifically if we're talking about foot and horseback. Presumably if I'm in a wheelchair, I'm allowed onto Dartmoor Commons, and so a further body of law, specifically equality legislation, could bear on some of these issues too. And the need to stop and pause could also be a manifestation of disability. So those must test the limits of the Dartmoor's arguments.
Yeah, I think it's really interesting. I think the 2 points, aren't they? So on the recreation point, you can see in Day. Let me tell you what happened in Day for those of you who aren't public land or obsessive. So in Day, Shrewsbury Council sold land that should have been advertised as an open space. So it should have been advertised under the Local Government Act 1972. It was not so advertised. Then Shropshire County Council granted planning permission. And the question was whether the public rights in this open space, which were created by a very quite complex piece of legislation, what the nature of these public rights were, and should they have been a material consideration in the planning decision. So it was an administrative law review of the planning application and the planning decision, because they were clearly out of time for the sale. And what the Supreme Court held was that these public rights were equivalent to other forms of public rights, particularly highway rights and rights in village greens. And so they could bind a purchaser, in this case, a developer. So after the decision came through, that was a great victory for campaigners, yes, because they had won the case. Now, for some time, the site remained locked up and it was not usable. And it's only recently been bought back by Shrewsbury Council. I think it's Shrewsbury. Peter Day will give you all the details on this if anyone wants to follow up. So the point was really this recognition of public rights as a category and how straightforward the courts were. So Lady Rose, in this fantastically clear judgment, is just very clear that there are public rights in land and they bind. We don't quite have the remedies point, that may come in future litigation. But in terms of village green, as I understand it, Jane, though you are much more expert here than me, the recreation point is about establishing the village green in the first place, rather than how you get to use it once it's established. So this word has morphed from, you know, maypoles to dog walking. So how do we recreate today in a modern way? And I think some of this is left unsaid. So I find it fascinating that in 1925 in the Commons provisional section 193 of the LPA, they did explicitly exclude camping for metropolitan commons. So it's not as if this was an unknown quantity, and certainly all the evidence shows that people were camping on Dartmoor. So it wasn't explicitly excluded through the schedules. So yes, I think recreation, I'm not sure yet it's a term of art. I think there's a good sprinkling of common sense. I always like the Supreme Court decision where they talk about the golfers and the walkers and everyone just very pragmatically gets out of each other's way. I think there's a level of pragmatism here that the Supreme Court have embraced to try to avoid absurdity. So I think it's a really interesting term that we will keep an eye on. Jamie, I think that's an excellent point. And I think, again, it shows that the interpretation that it's only on foot and on horseback must be, in statutory interpretation terms, absurd. It must mean something if it's ancillary. So one of the points that the Council for the NPA and OSS made was to rely on DPP and Jones. And DPP and Jones is a highways case. And it's also about what you can do that's ancillary to passing and repassing on the highway. And it's about a protest down near Stonehenge, but it's on the pavement. So it's not causing an obstruction. And there's quite a generous judgment about what you can do. And you can sketch and you can sing carols and you can do all sorts of things. But again, you cannot camp. Yes, which became relevant to Occupy later when they were on the highway around St. Paul's. Yeah. So what does it mean? What are these ancillary rights? If you say you've got no ancillary rights, you have no freedom to interpret this in the sense that's relevant today. And we say that statutes are always speaking. So access on foot would in 2024 surely be understood as access in a mobility scooter. And that's explicitly written into the 2000 Act. So I think you've come up with another brilliant example of why that just on horse and on horseback, it must be absurd. It can't be plausible. And if something else is allowed, then what? Are you allowed to go onto a tour to take a photograph? Are you allowed to scramble up a boulder? And because there's no restrictions in Schedule 2, the assumption I would have thought must be that you can, and that the Court of Appeal was right.
Maybe a question about ambiguity that you mentioned. When you mentioned the case of Whitstable and the development there, I just wonder what it means when public actors become private developers and the setting up of housing companies and others, where the boundary between public and private becomes even more blurred, and it's literally ambiguous in terms of how it's established. I just wonder where some of the legal debates fit into some of these things, because clearly there are issues around ethical and moral judgments about whether public actors should be speculating in land speculation, for example. But I just wondering about the legal implications and whether there are any judgments that we as planners, so myself and my colleagues know, but should be more aware of in terms of thinking about some of those debates about the financialisation of the public sector.
I can certainly send you a reading list. I'm very happy to do that. Yes, so the quote comes from Credit Suisse, which was, and the question is whether if an authority engages in a transaction which they do not have the capacity to engage in, whether that is then ultra vires. And that's largely been simplified through the Localism Act, which you will know well in Section 1 of the Localism Act. So some of that has gone away through legislative intervention. But what the courts have done have drawn this quite sharp divide between public and private law. And so that quote comes from exactly that kind of case, that the contract will continue if it was intra vires, and the public law considerations would be dealt with separately. So we see that there in a slightly different circumstance. But yes, I think, you know, you've got this distinction between public and private law, and public and private bodies and the extent to which they should be treated differently. In public contract law, it's also the case that the executive has capacity, inherent capacity, and local authorities are governed. And I think it doesn't sound very sexy, but I think it's so important and fascinating. Local government law, we should all be studying a bit more, because I think it's really interesting and really important.
Two more questions. Helen, you first.
Thanks so much, Antonia. That was really interesting. I think one of the things I really like about bringing these concepts together is it brings out the contestation and makes visible the contestation. And it's probably one of the few people who knows about leasehold law. I mean, I think we have to acknowledge that there was 100 years of efforts prior to the 1967 Act that was defeated in Parliament. So these things are highly, highly contested. But I think the issue then comes, what happens after the rights are granted? And perhaps this goes to your legal education, but how do you think we can get the judiciary to be much more conscious of this? I think we have to accept that those quotes you've given us are really quite exceptional judicial approaches to the potency of private property rights. I mean, what you see in leasehold enfranchisement is a chipping away constantly of the value of that enfranchisement, such that we have to have the 24 Act. It wouldn't have been necessary if the 67 Act had been allowed to flow, what they were, the 83 Act anyway. But so how do we get away from the potency of the discourse of the privateness of landlord?
Do you want to take another question or deal with this?
That's a big question. Yeah, I'll take on to give him some time to
Yes.
formulate.
Thank you very much indeed for the paper. Apologies if this is a wrong-headed question, but I'm just wondering the degree to which private law jurisprudence, developments in private law jurisprudence and land law might be contributing to this wider tendency towards propulsive constructions of public law related patterns. So I'm thinking about questions about expropriation of property. We already do that in freehold covenants, right? You know, you fail to bring your claim for an injunction in time, so you don't get the injunction. Effectively, your property right is destroyed. But also in the Regency Villas case, that more expansive for embracing a right to recreation in the law of easements. I'm wondering if there's the fact that these ideas are being embraced in the private law, case law is in a way paving the way for an expansion, a more expansive reading of some of the statutes that you've discussed in helping. I'm just wondering if the private law jurisprudence is in a way laying the ground to create this idea of public land law that you're driving out in the lecture.
Yes, I love that, because it speaks to Helen's question as well. And I think, so it won't come to many as a surprise that I am a deep skeptic about the public-private divide. And Peter Kane suggests that skeptics of the public-private divide often just don't see it. And this is one of my concerns. And Lawson in his Hamlin lecture says the same thing. He says the common law does not distinguish between public and private law. In the 1940s, Morton Horwitz said it was a sign of intellectual sophistication to assume that the public and private realm could not be separated. So in the 1940s, I would have been intellectually sophisticated. I think it's really difficult because it's become so entrenched. Now, clearly there are additional prerogative remedies, there are additional procedures in public law, but we could argue, and this is sort of the argument that Kane makes, is that we can argue for higher standards in public law without necessarily giving way in private law. My concern about private law is I think there is a narrative often that it's about the discretion between individuals to negotiate their way to agreements. So, I mean, Regency Villas was a case about easements, where actually there was a conveyancing mistake made. So we end up with this extraordinary situation where holiday apartments were entitled to an easement to use these facilities for a swimming pool or a golf course in perpetuity. And they could use their step-in rights to go in and fill up the pool or act accordingly. So I think there the sense of recreation is becoming quite broad, but I think it's quite different from being there as of right, regardless of an ownership interest. And I think this reduction to a two-party approach, I think there's a narrative in it, and I think it's about equality of bargaining power, and I think there's a particular perspective. So if we said, you know, is a contract private law? I ask my students endlessly, do they think contract is a private law subject? And they say, well, yes, of course. And I say, oh, what about an employment contract where you want to get the minimum wage? Is that a private law contract? And then they start to see my point of view a bit more. But I fail to really develop that with them. So I think the problem for me with private law is it often goes back to first principles, and it says I've got a willing buyer and I've got a willing seller and we're going to negotiate this. And I'm not sure, for me, there's a deeper question there, I think, about does the property right precede the legislation? And I think unless you're a natural rights theorist, we can say that over hundreds of years of England, Wales and the UK, we have a system where the common law accepts a property right, but it is authorised by legislation. So there is a kernel of a property right that you could build on. But I don't think that you have compensation every time that that's infringed. And I think I've shown that that's not the case. Contestation, how do we challenge the judges? I think I'm looking forward to the judgment in Dartmoor. And I think it will be interesting. For me, that's like a Christmas present. But I'd also consider, I'm very nerdy. I'd also consider what would happen if the Darwells won. If the Darwells win, it will be the biggest boost for access campaigning in a generation, right? We would get an extraordinary number of people who are concerned who would come together. So I think to some extent we all have to be careful what we wish for. Because I think we could argue, and that, you know, Guy Sharofsol and everyone in the Right to Roam campaign are doing a fantastic campaign on calling for an expansion to the right to roam. Now, the graphic I showed you, the right to roam from Guy, I mean, it shows you how disparate the right to roam areas are. It doesn't include public footpaths. And I would say public footpaths are the most important form of public space that exists, because without them, we'd all be trapped in our homes. We think about pavements and highways. Sorry, highways are the most important public right. So how do we change perspective? Dave and Shropshire really gave me hope. And I think the Village Greens cases give me hope. I think it's at the margins, but ultimately, I think it's going to be politics. And I think we have to lobby for what we believe in. And if we want more access, then that will be the answer. Because if the language is express enough, and I leave it to you whether you think the language in section 10 is clear and unambiguous, or whether ambiguity remains. I think it's clear because there is no Schedule 2 exception. I'm quite happy with that. But if we have clear legislation, I think the courts will abide by it, as they did with the right to roam.
I'm going to take a question from somebody online.
Great.
Who says, there are lots of abandoned houses in this country. Would it be illegal for the public to use them for recreational activities like gardening or even partying, since it improves social welfare and benefits the public interest?
Yeah. So, since 2012, squatting in a residential building is a crime. So that kind of self-help, which might once have been available, is no longer legally permitted. Whether it should be, again, would be a question of politics. One of my favourite pictures, which I never took, but which lives in my brain, is there were some squatters in a Starbucks, and they had a sign in Bristol, obviously in Bristol, and they had a sign up, and it said, "This is not a residential property, so the 2012 legislation does not apply, so we can adversely possess it." And so the answer would be, no, you cannot go into abandoned homes, but there are different rules for abandoned premises. Now, I'm not suggesting for a minute that you should engage in guerrilla gardening of that sort. But yes, I think the house building debate, to go slightly sideways, we concentrate a lot on supply, and we almost certainly need more supply. But we could also look at demand. I think it's something like 1.5 million empty homes, something like 27% in the city of London. It's an extraordinary number of empty homes.
I think we might be moving towards the last question or so. Any more? Last chance.
Planner and architect based in Norway, and we work a lot with planning applications. And so Norway is very different from the UK, so maybe it's an open question about certain strategy for city development and increasing access to both space and a certain type of services. So in many applications where we are looking at private developers who want to do certain things on the site, and we hope for better municipal services like footpaths or bike lanes or better street lighting, which would be considered public goods or public equipments. Municipality has no money for it. So what we do is we negotiate with the private developers, part of their property will be saved for public use and group as such. But I'm not the legal expert. I don't really know the sort of legal requirements or the specific frameworks it implies, but I just wonder if you see some risks in doing this sort of trade-off where basically we scoop out of the private property of these developers something like public equipments for a certain period of time.
Yes, I'm not sure I understood all the complexity about scooping out. Sorry.
So basically, instead of using the available public land, what we ask is of the private developers to parcel out a part of their property to install this public equipment. And I don't know if you see some risk in doing that, or if you think it's an interesting strategy when municipalities don't have the money to develop.
Sure. So we would have that in the UK, and the planners will know this in much greater depth than I do. But in the UK, that's usually achieved by what's called a Section 106 agreement. But it's one of the contradictions in public space that it's free to use and expensive to maintain. So that's kind of one of the inherent tensions that we have in public space. Whether or not it's a good strategy, I think, will depend on whether you can create enough income to maintain it. So one of the points I would make about public space is that it's kind of a Dorian Massey point, is that space is not static, space is ongoing. And for me, public space is an activity. It's not a designation. It obviously is a designation, and it's an important designation, but it's a designation that has effects in space and in time. And unless we address how we're going to do it into the future, then that's public space will become quite valuable. Sorry, vulnerable. So that picture in Whitstable, that the Victorians bought, or the Edwardians bought of that nice plot by the sea, had become neglected. And we saw that in Shropshire as well. That becomes used as allotments during the war, then it doesn't maintain itself, and then it becomes expensive, and then it becomes, and what we've seen is an enormous amount of privatisation, right? Because it reduces running costs, and for local authorities that have no funds, privatisation can reduce them from liability, can excuse them from liability. So I think there are mechanisms. What the Supreme Court held here was that when in Swindon, when they tried to do it via condition rather than a Section 106 agreement, that was not legal. So it had to be done by this negotiated agreement, even if the negotiation is something of a fiction.
That was more the Supreme Court's line. But yes, to what extent do we have truly public space? I think I would also say that public bodies themselves, and if you interview public authorities, they will have their own objectives and they will need to ensure that certain places are clean and tidy. So for one of my favourite public space examples, we interviewed someone once and we asked about handing out leaflets, and we said, you know, could we hand out leaflets here? And they said no. And we said, okay, why not? Expecting that it would be some prohibition on politics. And they said, no, because the leaflets get wet and soggy and someone might slip. And I think this is such an important, when you talk to people who manage public space, it really is about the ongoing management rather than the initial designation. And if you use a particular type of marble, again, we have quotes, that, you know, then would be used by skateboarders in Bristol, you know, and this wonderful marble just gets ruined very quickly. So then you try to push them to another area. So I'm not sure that public authority management of public space is always different. It's certainly not legally different from privately managed. There's a discursive element, you know, we should have the space, skateboarders should have somewhere to go. But I think ultimately it's about whether you can make it work financially. Can I just say thank you? Thank you to all of you for coming and giving up your lunch hour. And I had such happy years at the UCL at the Bartlett, and a little part of me regrets leaving every day. But yes, thank you so much for coming, and it would be great to keep in touch. Thank you. Thank you so much.